Okay, hello. I'm going to discuss the case of Citizens United versus FEC, no? With a focus on the majority decision. Okay, so we started our discussion with the presentation of the crux of the case. No? So this case is targeting the constitutional amendment, the first amendment. Which relates to abridging the freedom of speech, which is similar to the content of our very own constitution in the Philippines, Section 4 of Article 3 also, that protects freedom of speech in the Philippines. Okay, so by way of a case summary, so the Citizens United versus FEC was argued on March 24, 2009. It was again argued on September 2009, and it was finally decided on January 21, 2010. So the origin of this case is that it started, of course, with Citizens United, which is a non-profit organization who sought to air and promote a movie that they have made entitled Hillary the Movie during the primary season, okay, via video on demand. So they said that we're going to release this movie to whoever is interested, via a cable network. So, however, there's a problem with regard to this one because there is an existing or standing rule in the BCRA, or the Bipartisan Campaign Reform Acts, prohibiting the airing of electioneering communications, either broadcast, cable, or satellite, mentioning a candidate within 60 days for general election and 30 days during primary election. So with this, in anticipation of this, they challenged the BCRA electioneering communication limits also that prohibits corporations and unions from using their general treasury funds to make independent expenditure for speech. But before dwelling further into this case, our professor gave us a question. So, can individuals make campaign contributions? How about corporations? So, Attorney Noel Malimban correctly stated that individuals can make contributions to candidates, subject, of course, to limitations. And on the other hand, corporations cannot directly make political contributions, but they can make contributions or donations only through the PAC, or Political Action Committee. So that's the way how corporations will participate, right? So in this case, going back to Citizens United, so the questions presented in this case are as follows. Number one, can Congress prohibit corporations and unions from making independent expenditures or funding electioneering communications? And number two, is BCRA's disclaimer, okay, as to who paid for the advertisement and disclosure, okay, provisions constitutional as applied in this case? So it was ruled, and on the first issue, it was ruled by a very slim decision, that expenditure or independent expenditure ban is unconstitutional. It is against the freedom of speech, okay? And when it comes to disclosure and disclaimer rules, it is constitutional. Thus, by way of this decision in this case, corporations and unions may now spend unlimited amounts independently, but they must comply with transparency rules. So that is the gist of the decision. Now, with this decision, the court has overruled a previous decision in the case of Austin, okay, in 1990, on anti-distortion rationale, and parts of another case, McConnell versus FEC, approving electioneering communication limits. But when it comes to disclosure, it remains to be the same. The rules remain to be the same. So, dwelling on this case of Citizens United, our professor wanted us to link the two cases that we have discussed, the case of 303 Creative and Citizens United. So our classmates gave a very wise answers, of course. And it was said that in both cases of 303 Creative in Citizens United, these are both test cases, no? Because they lack actual controversy. And another of our classmates said that the decisions in both cases are based on the uh, justices' ideological beliefs, no? So in the end, it was stated by our professor that in both cases, the courts are acting like activists. Among many cases, uh, they ignored the stare decisis. No? In deciding on these cases, they ignored precedents. Okay, precedents. So they made something new, so to speak. No, so in deciding on these cases, one thing that is also not to be out of the picture is uh, the, the 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 concept of strict scrutiny as regards freedom of speech. No, so what is the standard of judicial review? Okay, so the standard is that the government needs to show that restriction essentially serves compelling interests with narrowly tailored means. No, so what are these three compelling interests? It was said that number one is anti-distortion, equalizing speech, and very important, stockholder and shareholder protection, because in corporate setting, it is the board of directors and the officers who are uh, deciding on matters regarding the corporation. And our professor correctly asked the question, then what is missing? What is missing in this process? So Attorney Don correctly explained that the stockholders' point of view is missing, because stockholders, being part of the corporation, have also the right to dissent in the corporate act, like the decision to make political contributions. So with this, applying this majority decision, so there is core political speech that needs strict scrutiny. So first and foremost, the First Amendment protects freedom of speech, not the speakers, as also was discussed in the case. And compelling interest limited to preventing quid pro quo, okay, which is happening in so many places. And independent spending is not equal to uh, quid pro quo. And more importantly, PACs are not an adequate substitute for corporate speech. And PAC requirements impose significant burdens and do not cure uh, speech ban. No, okay. So those are the things that I would like to share. No, and speaking about the videos, no, that was assigned to us, I would like to quote some of them with the case of then former President Obama. He said, "With the Citizens United, anything goes. There are no rules on how to finance political campaign, and nobody is exempted in America." Okay, and Monica Yuon also in the lengthy discussion, she said that if the court says money is speech, then it knocks the checks and balances out of the equation or the picture. So this case of Citizens United did not actually clarify the vagueness of the law, okay, when it comes to political communications. It did not, okay. And Justice Scalia said in his interview that was assigned, he said, whatever happens, okay, the premise of democracy is that people can discern. So we should not underestimate the understanding of people. So the First Amendment protects speech by associations that includes corporations. So that ends my short summary, and I hope that the dissenting summarizers can also give their piece.
A pleasant day, Prof. and classmates. My task is to provide a post-class summation on the dissent in the case of Citizens United versus Federal Election Commission. First, I will present the main issue as discussed in the Citizens United case, then move on to the key points raised during the class discussion with a mention of their contributors, and lastly, I will provide a conclusion. For the main issue, whether a federal law that prohibits corporations and unions from using their general treasury funds to make independent expenditures for speech defined as an electioneering communication violated the First Amendment's guarantee of freedom of speech. For the majority, yes, the law is an outright ban, a ban on corporate speech, notwithstanding the fact that a corporation has the option to form a political action committee or PAC. For the majority, these PACs are burdensome alternatives. They are expensive to administer and subject to extensive regulations. Also, the majority argued that the First Amendment protects speech and speaker. The majority recognized that First Amendment protection extends to corporations. But for the dissent, led by Justice Stevens, neither Citizen United nor any other corporation's speech has been banned. And to elaborate on this stand, let us look at the key points raised during the class discussion based on the transcript. Key points discussed by Attorney PJ, Attorney Jmar, Attorney Carlo, and Attorney Roger. For the first key point, overview of the dissent by Attorney PJ gave an overview of the dissent and he mentioned two key points based on Justice Stevens' arguments. First, there was no ban on corporate speech. Attorney PJ emphasized that according to Justice Stevens, corporations, even before the Citizens United case, had the freedom to speak through PACs, but these PACs were heavily regulated. But despite being heavily regulated, this did not mean that there was a complete ban of corporate speech. Also, Justice Stevens added that there was really no ban on corporate speech because stockholders or corporations can, on their own, engage in electioneering campaigns outside of the corporate form. Second, on the issue of identity based distinctions, Attorney PJ stated, based on the opinion of Justice Stevens, that if we allow corporations to have unlimited right of speech, being non natural persons, they can have unlimited sources of financing. And hence, corporations can engage into electioneering campaigns without limits, and corporations may also demand that state to vote. For the right to vote is also a form of a free speech. Next key point, a discussion on stare decisis and historical figures by Attorney Jmar. Prof. then raised the question, what was it that the dissent used to attack the majority's decision that was classically a majority kind of weapon that was oftentimes used? Attorney Jamer pointed out two things that they used. He said number one would be the concept of stare decisis, and more importantly, they tried to look into the historical figures on when the Constitution was framed, saying that at the time, corporations were really frowned at by the framers of the Constitution. And so when they created the freedom of speech, they were only pertaining to natural persons because it is for the dissent. It is impossible for the framers to even consider corporations as people having that kind of rights. And Prof then agreed that absolutely the idea that corporations they're not supposed to be speaking, they're not real people, and the liberals on the court were using historical originalism to justify or to argue that the majority was wrong and was using the majority kind of approach against them. Another key point, comparison between an artificial being and a natural person by Attorney Carlo. Attorney Carlo discussed that one of the issues in the dissent is the comparison between an artificial being created by fiction of law and a natural person exercising freedom of speech and expression in political views. And one point is that a corporation is being represented by its executive officers, such as the board, and the members of this board is subject to change, and the corporation has a different standard political views. And basically, it must not be given the right of freedom of expression or of speech per se, unlike a natural person. And Prof. then raised another important point, a thought provoking question on how to distinguish between an association of people trying to say something collectively versus a corporation saying something collectively. He pointed out that this was one of the things Justice Scalia was saying, is that the corporations are essentially associations of people, each of whom have rights, and those associated rights flow into the corporation, just like an association. Lastly, this key point is worth emphasizing, for it now gives us Justice Scalia's opinion on Justice Stevens' discussion of the First Amendment by Attorney Roger. Attorney Roger mentioned the point made by Justice Scalia in his concurring opinion that, indeed, when the First Amendment was constitutionalized, the framers had in mind the free speech of individual Americans and not of trees or polar bears. Attorney Roger added that Justice Scalia emphasized that the individual's right to free speech includes the right to speak in association with other individual persons, and that the First Amendment is written in terms of speech and not of speakers. Also, Justice Scalia said that the text of the First Amendment offers no basis for excluding any category of speaker from single individuals to partnership of individuals to incorporated associations of individuals. And he said that the dissenting opinion offered no evidence about the meaning of the original text in support of the conclusion that the First Amendment excludes corporations. As a conclusion, based on the key points, is the majority correct? Is the dissent correct? Is there really a ban on corporate speech, or is there no ban at all? Or the real issue in this case is not really about whether there is a ban on corporate speech, but rather whether the government has the right to regulate corporate speech. Indeed, the Citizens United case is a challenging case to discuss in class, but again, the class did a great job. Thank you, Prof. and classmates.
So, good day, everyone. This presentation summarizes the four groups' arguments on Jimmy Kimmel's suspension, relating them to the U.S. case, particularly Perkins Chloe versus DOJ, and the Philippine cases on ABS-CBN and Rappler. So there are four groups. The first two groups will be lawyering for Kimmel, and the third group will be lawyering for the state, while the fourth group will discuss a comparative analysis of Kimmel's situation with Philippine cases. So, for the first group, they were led by Attorney Donoan. They argued that Kemal's suspension amounted to unconstitutional retaliation since the FCC chair criticized his remarks before ABC suspended him. They argued that the government effectively pressured a private company to silence speech, as it was emphasized by Attorney Donoan that Jimmy Kimmel's remark was made and then after that he was suspended. So the FCC is part of the government, and that it what it did was effectively influence ABC to suppress the First Amendment right of Jimmy Kimmel. So for the second group, they were represented by Attorney Banikad, and they relied on the Perkins Coie. They argued that, like in that case, government pressure indirectly silenced protected advocacy. So Professor highlighted the First Amendment retaliation test, which was used in the Perkins Coie, and applying the test, it would show that Kimmel's suspension satisfied all the three elements: the protected speech, retaliatory action, and the casual link. Attorney Banikad emphasized in her report that this raises the same constitutional issue, and the question was Kimmel's speech suppressed because the government pressured or coerced private parties to act against Kimmel. So for the third group, they were represented by Attorney Mark Madalang, and they are defending the state. They emphasize that the First Amendment restrains only or applies only to government actions. So ABC suspension was a private employment matter, not a constitutional one. Since FCC never issued an order, the claims of government pressure remains speculative. Thus, unlike Perkins Coie, this is not a First Amendment violation. Attorney Madalang emphasized during his report that it clearly appears that it is a private relationship between an employer and an employee. The connections argued are merely based on conjectures and surmises. So for the fourth group, they were represented by Attorney Rani Ramos. They drew Philippine parallels. So ABS-CBN was shut down after its franchise renewal was renewed under political pressure, while Rappler reporters were banned from covering the Malacanang. Both cases, accordingly, show how executive power can be weaponized against the press. Although the Supreme Court dismissed Rappler's petition as moot, Justice Leonen's dissent stressed that the issue could recur. Attorney Ramos emphasized that when Duterte got into power, he pressured Congress not to renew ABS-CBN's franchise. In Rappler's case, reporters were not allowed to join press conferences. Rappler said that this was an attack on press freedom. Uh, So when comparing these cases, we see a spectrum. In Kemal's situation, this raises the question of indirect state pressure. Perkins Coie involved clear retaliation against advocacy. In the Philippines, both ABS-CBN and Rappler show direct state action. Across all contexts, the challenge is protecting free expression from both subtle and overt suppression. As emphasized by our good professor, that the question would be, did they take an action sufficient to deter other Jimmy Kimmels out there from speaking again? So to conclude, uh, free expression is vulnerable whether under direct government censorship or indirect corporate suppression under state pressure. The cases or the situation of Kimmel, the actual case of Perkins Coie, the ABS-7 case, and Rappler's case all underscores that safeguarding democracy requires vigilance against both retaliation and censorship in any form. So this summarizes the four groups report and in relation to the case of Perkins Coie and the Rappler and as well as the ABS-CBN case. So that's my part for this class discussion. Thank you.